Yes, sir.
Well, that's a nice start.
Lady got there again. She will get this. Sorry, it's Ray. Oh, that's right, Ray. He's gonna apply for this commissar, so those two. Would you prefer to have it down?
No, they're fine. I need to sit. Have a seat. Because we need to go over the instructions.
Yes.
All right, Mr. Kennedy, you're here this morning because charges have been filed against you by the state of South Carolina. The state of South Carolina and the United States Constitution afford you constitutional rights regarding these criminal proceedings. Those rights being the right to a trial by jury and the right to an attorney. Understand that having the right to an attorney does not mean this court has the authority this morning to appoint an attorney for you. It simply means we must inform you of that right. The charge that you have against you this morning is a general sessions charge. Therefore, you will not receive a court date today. However, once that court date is set, you do need to make sure you show up for your trial date. If you fail to appear for your trial date on this charge in that court, you can face a fine of $5,000 or imprisonment of 5 years or both. And because you have a general sessions charge, you are entitled to a preliminary hearing. This is a hearing where the state must show that it has the probable cause to go forward with your case. It is not required or mandatory. It is a hearing that you and or your attorney will decide if you want to request. At this hearing, you will not testify, you will not introduce evidence, nor will you call witnesses. The only thing you and or your attorney can do is cross-examine someone who may testify against you. You have 10 days from the date you receive this request to either submit it back here to our office or to the office of the clerk of court located at the main courthouse at 180 Magnolia Street. Unlike your preliminary hearing, your date of initial appearance is required or mandatory. That means you must appear for it. It is held at 22 at 9 o'clock in the morning. You need to be in that assigned general sessions courtroom. If you have an attorney on record, you'll sign in and you will sign out. If you do not have an attorney, you still need to show up, you'll sign in and remain there until you are excused by that circuit court judge who will explain to you the importance of having an attorney in a general sessions charge. If you fail to appear for your date of initial appearance, that circuit court judge will issue a general sessions bench warrant. That bench warrant will bring you back here to the jail where you will remain until that circuit court judge calls for you to come back before his or her court. Given the issues and the problems with the court docket and the judge, that could take quite some time. We've had folks to spend in excess of 6 months in jail simply because they chose not to appear for their date of initial appearance. So make sure you show up for your date of initial appearance. If the charge that you have against you this morning is null pros, dismissed, anything other than you pleading guilty or being found guilty, you do have the right to have this charge expunged or removed from your record. Since this is a general sessions charge, if that were to be the case, in order to have this charge completely expunged and removed from your record, you or your attorney will have to contact the clerk of court, and there's usually a fee associated with that. Whether you are released on a personal recognizance bond or a cash surety bond, you're released on a condition of good conduct. That means you cannot get into any more trouble while you are out on bond. If you do, the solicitor's office can request a bond revocation hearing. As a result of that hearing, your bond could be denied, a higher bond could be set, or a bond with more restrictive conditions could be placed upon you. If your bond carries conditions, do not violate the conditions of that bond. If you do, you can face a bond revocation hearing or a contempt of court hearing. I will caution you that anything you say in this arraignment can be used against you in court. Therefore, it's in your best interest not to discuss the facts of your case without first speaking to your attorney. If you start, I will ask you to stop. Not being rude, we do not want to have to go to court and testify against you. I'll also caution you that anything you say to another inmate or one of the deputies here at the detention center regarding your case, they can be subpoenaed to court to testify against you. All right. Come on up, Mr. Kennedy. You're going to represent him through the entire process.
Most likely, Judge, yes.
All right, Mr. Kennedy, you've been charged with felony DUI resulting in death. That can carry anywhere from 1 year in prison to that of 25 years in prison, and a fine of $10,100 to that of $25,100. And at this time, we'll hear from the solicitor.
Okay. May it please the court, Your Honor. Just briefly giving you the facts on the case, Your Honor. Yesterday, about 12:40 p.m. in the afternoon, Your Honor, the defendant was driving his vehicle. In this case, a 2011 Ford F-150, Your Honor. He drove the truck literally down a road where there's just two houses, completely a different direction where he was from. He did talk to law enforcement, said he met a friend near the Walmart neighborhood in Cedar Springs. He took a hit off a vape pen, basically took a deep draw, is what he told law enforcement. After that, he started driving, feeling the effects of it. He lives in Roebuck. The direction he would have went was the complete opposite direction of what he was going on Southport Road, 295. He goes down 295 by the Bassett or BAS plant, Your Honor, there. He goes on West Murph Road, Your Honor. Basically, that road only has two houses on it. I've got pictures I'll be showing you too, Your Honor, as well as the map. He goes down, in this case, Mr. Parrish, the victim, he works on boats there at his house. He has garages, different things there. He was getting ready to work. He was actually in his driveway and talking to the family members. They'll be able to tell you more in this case. And was hit in his driveway, drove into his garage at that point. The defendant literally ran over top of him. I have a 911 call I like to play for the court at the appropriate time also, where his daughter goes out, Kelsey, and finds him. And they say that the defendant was literally holding him, the victim, when he got out there. Can I play that 911 call this time around?
Yeah, you may.
I won't play on my phone if that's okay.
Or 911, what's the address of your emergency? 270 West Murph Road. You said 670, what's the street name? I don't know. 270 West Murph Road. West Murph Road? Yes, ma'am. Okay, that's the one that runs right off of, like, South Fort? Yes, ma'am. Okay, what's your name? Kelsey. Alright. What's your telephone number in case we get disconnected? 864 590 7898. Okay, what's going on? Please hurry, I don't know.
I don't know if you heard that last part, that was the defendant there, saying he's sorry at the time from there. You know, he's admitted to doing this. I do have the pictures I'd like to show you, Your Honor. I've shared this with the defense already, Your Honor. Or that's a map. You'll see Southport Road's 295, and you see the plant right there, and you see, actually turn around, Your Honor, from there. 295 comes down, and he had to go to Bassett, and this is the road, and there's only 2 houses on it, Your Honor. And I don't know what the odds of somebody going down that road, and then you'll see on this, starting from there, there's the driveway that he drove down into the area that Mr. Paris was in, Your Honor, in that case.
How long is the driveway?
I think approximately 150 yards. I got Sergeant Elrod with me.
175 yards.
175 yards, Your Honor.
To the front of the building.
To the front of the building, Your Honor. But I believe in talking to his family, Mr. Paris, his brother will tell you, it was basically, he was working actually out front of the garage. And when he got hit, they said they found his cell phone, different clothes and things there, Your Honor. It looks like that he went underneath of the garage door, went in, and the garage door went down. There's a hole in the garage door, but I think that's where firefighters or people that got into it from that standpoint. So he's literally in his driveway, getting ready to work that day. And from the imagination from there, there's no question his driving was extremely reckless and dangerous in this situation. A man's at his own house, standing there, getting ready to work, and he gets hit by this individual. I know he was sorry. He did say on the 911 tape, and he was holding him, but he did this. And if he did off one vape, I can't imagine. The scary thing today, he's only 17. He shouldn't be having a vape pen anyway. Nobody should be giving him one anyway in this situation. The vape pens now, we have all kinds of different marijuanas out there. We have Delta 8, Delta 9, Delta 10. I've heard all kinds of things over the, concerning that and the dangers that are lacing these pens with. And for people to take hits off of them and get under this kind of effect from that standpoint, it just shows how dangerous it can be from that standpoint. But I know the family wants to not ask to not bond. I joined in with that. In this case, I know several family members like to speak at the appropriate time. He does not have a prior record, Your Honor. And you may have already seen that from the information you have from there. But do you want to hear from the family this time?
Yeah, we'll hear from the family.
I believe, Your Honor, in this case, Ray Paris, his brother, would like to see him first, Your Honor. He can actually tell you more information about where his brother was standing in the driveway and so forth.
He was standing in the, I'm Ray Parrish, I'm Larry Parrish's brother. I do know he was standing in the driveway, walking to his shop on his telephone, when he got hit from behind and drove him through the building, and Larry ended up laying in the floor inside the shop. I wanted to address that because under the news and all is saying that he was already in the shop, but he was not. He was outside walking to his shop to go inside his shop to work when he got hit. I do know that, but I wanted to address the court that part.
Okay, Your Honor, and also there's 4 other family members here, Your Honor. In this case, there's Tammy Pridemore, Your Honor, DJ Gray, Amanda Gray, and Matthew Paris. In this case, I think Ms. Pridemore wants to address the court, Your Honor.
I want to ask that the bond be denied because you don't have any other offenses. But I do think he's a danger to society because he came from Roebuck, 25, 30 miles, drove down a half a mile road that God knows why he was there, and plowed down one of the best men you would ever meet at home, minding his own business. He took away a husband, a son, a daddy, a brother, a best friend. We don't know how we can't bring him back. And so, with that respect, if he can come from Roebuck and go down a half a mile road that you wouldn't even know existed and kill an innocent man, then what else could he do? Larry is in the morgue. And that's all I got to say.
Thank you.
And Your Honor, he worked on boats. And I don't know if you saw in the picture, that's what he did with his life. And, he's well known for his work on boats throughout the communities in this case, Your Honor. Yeah, Sergeant, otherwise, Your Honor knows that he has anything else to add. And the family members want to speak. Thank you. Oh, I'm sorry, we do have, in this case, Kimberly Cockrell from MAD, Your Honor. She's up here representing them, as well as Sarah Cove from the Highway Patrol, also their representative here, Your Honor. And I believe she wants to address, and the family did want her to address the court, Your Honor.
Sarah Cobb, the victim advocate with the South Carolina Highway Patrol. The Highway Patrol would also like to reiterate Solicitor Barnett as well as the family's request and bond being denied. He's a clear danger to the community, driving approximately 175 yards down a driveway out in the middle of nowhere, killing an innocent man, doing what he loved to do, or headed to do what he loved to do, is outrageous, and we would just also request that bond be denied, Your Honor.
Your Honor, Kimberly Cockrell, Victim Services Manager, Mothers Against Drunk Driving. Your Honor, this was Larry Paris and his daughter Kelsey. Kelsey, who you heard on the 911 call. Your Honor, he and his wife Donna have been married 35 years. He loved his wife Donna and their daughter more than anyone in this world. Your Honor, he was an avid fisherman. He was an avid hunter. He would do anything for anybody without any questions asked. Your Honor, the defendant in this case knowingly and willfully violated the laws of our state when he got behind the wheel of that truck under the influence. He made a choice, Your Honor. Larry also made a choice. Unfortunately, one of those choices ended a man's life. So, Your Honor, on behalf of Mothers Against Drunk Driving and the victims in this case, we're requesting that bond be denied as well. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Ryan Beasley, here on behalf of Caleb Kennedy. Your Honor, this is obviously a terrible, terrible accident. And, you know, there's a lot of people who've been saying a lot of things, but no one knows all the facts at this point. One of the things that nobody knows is he was actually on his way to Union to go see his girlfriend, which is why he was not going to Roebuck. Another thing is there's medication that we think there may have been a bad reaction to that he is prescribed that will come out eventually. I mean, this is obviously not as egregious as most of the cases we see down here, and most of the cases I don't see the solicitor's office down here on, which are somebody that involves tons of alcohol, being at a bar, doing a lot of bad things. We're talking about a freak situation in the middle of the day at lunch by a minor who's in the 11th grade. By all indications is a great student, never been in trouble. It makes absolutely no sense why he would wander down some road and you know, be in this terrible accident. And I can tell you, as you sit here, you can tell he is absolutely so sorry for what happened. I mean, you could hear him on the 911 tape. He was holding the defendant, telling him he's sorry. This is not somebody that's a danger to society or a flight risk. I mean, he's only 17, Judge. He's in high school. He is not a danger and not a flight risk. No record. Your Honor, and he's cooperated fully with law enforcement. That's why they know the things that they're alleging, or think that they're alleging. But Your Honor, there's been bonds set on much more egregious cases than this. And, I mean, on hundreds of cases. And there's no reason a bond should not be set on this kid down here. I mean, all we're going to do is if you don't set a bond, a general session judge is going to set a bond, but it makes no sense to wait that long because the facts lay out of somebody deserving a bond. His parents are here. He lives in the community. He's lived in his community his whole life. You know, I think unfortunately for him, he was on American Idol, which is why everybody's here. Otherwise, nobody would be down here. At least not the solicitor's office and TV cameras. Thank you, Judge.
Your Honor, may I respond just briefly? Your Honor, I think you know me. People in Spartanburg County, the news knows me. I come on felony DUI bond here. I've been on numerous ones. And to say that I just came for this one, I would be here no matter what the felony DUI was in this situation, whoever it was. So I just want to make sure that's perfectly clear for the record from that standpoint. And obviously, you know, the issue is, I understand what happened. The felony DUIs are some of the most dangerous cases because these people never knew each other. And the connections that happen here, and that's what makes these things so dangerous. And I've handled these for over almost 30 years of my career. So I just want to make sure that's clear for them.
And Your Honor, and I'll like just to also add, he can also verify that there's a much more egregious felony DUIs that there have been bond hearings given on, and he can verify that as well, Your Honor.
Well, we're not here to try a case. We're here to set a bond, okay? All right. Based on the facts of the case and what I'm going to do this morning, Mr. Kennedy, I am not going to set your bond this morning. I am going to let a circuit court judge set your bond, okay? And what your attorney will do is file a motion with that circuit court to have your bond set, okay?
Please.
Did you understand that sheet on the information regarding your rights that you were given to read? My copy. What I gave your attorney is a request for a preliminary hearing. He'll either submit that or file one on his own, okay? You've got a date of initial appearance. It's scheduled for April the 14th, 2022 at 9 o'clock in the morning. You understand that? That's where you got to show up and say, I have an attorney or do not. You do sign by that X right there. Do you want to receive a text message or voicemail reminding you of your date of initial appearance? Give me your cell phone number.
864-310-9233.
I can get you to sign on the left-hand side saying that you do agree to that. All right, this is a copy of the checklist that we're about to go over. This is your copy, and hopefully your attorney, if he remains with you. However, if you get to a point where you can't afford an attorney, I did put the number on the back there for the public defender's office, okay?
Thank you.
All right, we're gonna go over this with you. Number 2 says you understand if you don't show up for your trial date on this charge in the circuit court, you could face a fine of $5,000 or imprisonment of 5 years or both. You understand that? And I'm gonna ask you to take that pen there and put your initials on that line there beside number 2. Number 3 says we've given you in writing and we've explained to you your right to a preliminary hearing, and your attorney has that in hand. I get you to put your initials beside 3, and you and he will decide if that's something y'all want to request. 4 says you understand you have a right to a trial by jury. Do you understand that? Put your initials beside 4. Number 5 says we tell you what you've been charged with. We told you the penalty for that charge. We talked about attorneys, and you've got your own attorney, so put your initials beside 5. And the only other thing I'm going to get you to initial, number 8, does not have a line. But if you change your address, it's your responsibility to inform your attorney and the court of that change of address so they know where to reach you, okay?
Yes, sir.
Put your initials beside 8. And then let me get you to sign it by that X there saying that everything you initialed, I went over with you. Any questions? All right. Did you need some time with him?
That'd be great, Judge.
Yeah, we can do it.
Okay.